Hi, I'm doing well. How are you?
I'm great. I'm great. So, how can you hear? Can you hear me? Is audio okay?
Yes, it's good. I can hear you.
Okay, good, good. So the topic of the day is all about your driver's license. I'm sure if you're just charged with a DUI, you're incredibly concerned about keeping your driver's license, preventing revocation, and what exactly are the Colorado laws that you need to know, and maybe you can start addressing some of these topics.
Right. Okay. This is a complicated subject, so let me take it one at a time. To start
Okay.
with, um, what we call an express consent revocation. That's what most people who get a DUI. That's what they're immediately looking at. That is what happens if you take a breath or a blood test and get a result over zero point zero 0.08, or you refuse to take a test. Either way, you're immediately looking at an express consent revocation, and you actually get served with a notice of revocation on that. And it's an administrative proceeding separate from the criminal proceeding, entirely separate. It kind of has its own life. Um, and
How soon after the arrest would people get their license? You said an express consent revocation. How
Correct.
quickly does?
Okay, how this happens is, say you get if you take a breath test and they have a result of a point zero 0.08, then they're going to right then they're going to serve you the notice of revocation. If you refuse to take a test, they're again going to revoke your license for the refusal part of that. The theory is that you've given your consent to take this test by driving on the roads, and that therefore whether you believe that or not, they're going to punish you by not taking a test for taking your license that way. Now, if you take a blood test, those results are going to take some time to get back. But if usually anywhere from a month to 6 weeks, and then if your blood test result is over zero point zero 0.08, they'll mail you a notice of revocation. In any way you get this notice of revocation, you must take action and you must request a hearing in order to protect your rights to drive, because they've already telling you that we've taken your license. It's happened. If you want to challenge that, then we'll give you a hearing and you can challenge it, and you can drive them to the hearing date. So that's how that works. So if you're facing one of those, what we call an express consent revocation, which is a part of almost every DUI, unless your BAC is below zero point zero 0.08, the only other alternative could be is if there was a suspicion of driving under the influence of drugs. There is no express consent level upon which your license will be revoked necessarily with the positive drug test yet. All right. So in any event, so if you have this revocation pending, what you're looking at initially is requesting the hearing. Now, what can happen? You can drive up into the date of the hearing. If you fail to request a hearing, then that suspension will take effect immediately. If you at the hearing date you have the hearing and you end up losing the hearing, then what you're facing is as follows. If it's a first offense and your BAC is below 0.15 but over 0.08, so you took a test, but the results came back and they're over 0.08 but they're under 0.15, you're looking at initially a 9-month suspension. But you can get your license back after 1 month of no driving if you put an interlock device in your car. The interlock device, you have to apply for this. It's called a restricted license. That's a technical name for it. This replaces the old system we had of what was called the probationary license. That no longer applies under this circumstance. For an express consent revocation, the way to get your license back early is to put an interlock in your vehicle after 1 month. Now, I want to point out that the application...
Complicated. How I'm sure everyone would want to know how soon after the time of arrest could they apply for and receive an interlock device in their vehicle so they can get back on the road.
Okay, so as it works, after you've been cited and given a notice of revocation, you have 7 days to request the hearing. If you request the hearing, you can drive up into the date of the hearing. If you fail to request the hearing, then that suspension takes place on the 7th day. At that point in time, either at the hearing if you lose, or in the 7th day if you don't request the hearing, either way, your suspension begins to run then. Now, you're eligible to get a restricted license, as I said. And that eligibility, if you're over 0.08, below 0.15, is after 1 month of no driving, you can get an interlock device. You're eligible to get it in. the application process takes about 3 weeks. So I would say a week after you end up losing the hearing or not requesting the hearing, a week after that, you want to start this application process. There's some certain things you have to do. You have to get SR22 insurance. You have to put the interlock in your car. They give you a certificate for that. You have to sign up for a level 2 alcohol class. And then there's an application you fill out. And if you put those 4 things together and send them to the DMV, there's no discretion anymore. They used to be able to have a hearing and you had to convince them that you needed the probationary license. Now, they don't care. I mean, I don't know if they care, but they are not statutorily allowed to consider anything other than these facts I'm talking about. Was your blood over 0.04 or 0.08? Sorry. If it was, and it was below 0.15, then you have to maintain that interlock for 4 consecutive months with no lockouts in that period of time. And if you do that, then you're a fully licensed driver again. So that's if you're a first-time offender, between 0.08 to 0.15. Now, if you're a second-time offender, if you have a previous revocation on your license, or you have a BAC over 0.15, or in that circumstance, you have to maintain that interlock device. You're eligible after 1 month to get the interlock in, just like with the lower BAC or the first-time offender. You were eligible after 1 month, but you have to maintain that interlock for 2 solid years. So it jumps from 4 months with a 1.5 to 2 years with anything over 1.5, which is a pretty long time. Now, if there's a refusal, that's true. Now, if there's a refusal, that's a slightly different circumstance. If there's a refusal, you're not eligible for a restricted license for 2 months. The old situation used to be you lost your license for an entire year, but that's no longer the case. Now you're eligible after 2 months, and again, remember the 3-month lag time to apply. After the revocation, if you have the hearing or if you don't fight the hearing, after the revocation is made final, you have 2 months you can't drive, and then you put interlock after that and maintain that for 2 years, and then you can reapply to get a license at the end of the 2-year period. So that's, in a nutshell, the basic main ways that revocation people are looking at and whether they're able to drive or not. Something I want to point out is that this statute does not allow any wiggle room for need or high needs or personal circumstance or whether you lose your job. None of that applies. This is statutory, so that the hearing officer has no discretion to give you a break when those situations occur. It's unfortunate, but that's the way it is. So if you fall into these factual situations, these are the results we get on the outcome. So again, another reason why you really want to fight these hearings, you really want to request a hearing, and you really want to hire a lawyer to handle the hearing for you, just to make sure that you've done all you can to preserve your right. And one point I note, look how this jumps from being a 0.15, you say you're a 149 to a 0.150. You've jumped from 4 months of interlock at $70 a month to 2 years. That is a big leap up, and I can tell you that some of these tests, for a blood test, I can get that retested. Sometimes if it's a 0.150, I can get it retested and it might come back at a 145 next time. I regularly do that, and it's pretty common, and that can save you a 1.5 years of interlock. So very important that you want to talk to a lawyer about that.
Wow. Okay, that's very important. So very good information, David. Thank you very much. And
sure.
Talking to you soon. Take care.
All right. Thank you, Jamil.